Hey, good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes, and I'm the presiding judge here at County Court at Law Number 2. Now, you have been asked to come to court today for what we call an arraignment. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case, but it is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are referred to as your more serious type offenses, whereas your misdemeanor cases are referred to as petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony offense. And when I use the term serious, what I'm talking about the facts of the case and the possible punishment that you can receive if you are found guilty of the offense. Now, felonies are divided into 5 categories. We'll start at the top and work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. Now, if you're convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. If you're convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine that does not exceed $10,000. If you're convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment, if you are found guilty, is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, you have a misdemeanor, so you don't have to worry about those type of punishments. However, misdemeanors are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, the Class C misdemeanor, the range of punishment is fine only. You cannot be given a fine that does not exceed, you can be given a fine that does not exceed $500. You can't get jail time, fine only. Now, those Class C offenses start in the city court or the JP court, and they come to this court when a person is found guilty in one of those courts, and then they appeal their case. They ask for a new trial, it comes to this court. The range of punishment does not change. For example, a Class C misdemeanor could be not having your seatbelt on, speeding, having an inspection sticker that has expired. Those are Class C misdemeanors. Now, if a person fails to pay the fine on the Class C misdemeanor, or if the fine was converted to community service and they failed to perform the community service, then the court can issue what is called a capias pro fine. What that means is it's a warrant for your arrest for you to sit out the fine in jail or pay the fine. Now, the next highest misdemeanor is a Class B misdemeanor. Now, the range of punishment for a Class B misdemeanor, minimum 0 days to a maximum of 180 days, which is 6 months in the county jail, or a fine from $0 to $2,000, or you could be given both such fine and confinement. Then you have the highest misdemeanor, which is a class A. The range of punishment for a class A misdemeanor is $0 to a maximum of $4,000 fine, or you could be given jail time from 0 days to 365 days, which is a year in the county jail, or you could be given both such fine and confinement. Now, you may be eligible for probation. Probation basically means you don't go to jail. You serve your punishment in the community. Now, with probation, there are two types of probation. One type of probation is called unadjudicated probation. Unadjudicated probation. And what that means is you don't have a conviction on your record. And if you successfully complete the probation, you may qualify for what is called a non-disclosure. Non-disclosure means that your record is sealed, and we cannot disclose the fact that you were on deferred or unadjudicated probation to the general public. Now, if you violate your probation will be revoked. And if it's revoked, you can get a conviction. Okay. Now, the next type of probation is called adjudicated probation. First one was unadjudicated, and the second one is adjudicated. With adjudicated probation, you do have a conviction on your record. However, there is something that is called judicial clemency. What that means is the judge can set your conviction aside, and you will no longer have a conviction on your record for that case. Now, in order to qualify, three things has to happen. One, you have to successfully complete the probation. Two, there cannot be any more time left on your probation. And three, you have to be successfully discharged off of the probation by the probation department. And if those three things happen, then the court has the discretion to set your conviction aside, which means you will no longer have a conviction for that case. Now, if you get a subsequent conviction later on, okay, then the case that you got judicial clemency on can be resurrected, revived, or brought back up, and it can be used against you. And if you try to get a license with CPS, Child Protective Services, then they can either deny giving you a license, or if you have a license, they can suspend or revoke your license. Okay. Now, everyone who's here should have a clipboard with paperwork on it. You have one? Who does not have a clipboard with paperwork on it? Okay. And the reason why I say that is because I'm getting ready to go over that paperwork with you right now. The first page that you should see should be a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Okay, you see that document? Judge's Explanation of Rights to Defendants Without Attorney. This document explains the rights that you have regarding your right to have an attorney. Okay, it basically states that as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Number two, if you cannot afford to hire an attorney, you may request that an attorney be appointed to represent you. Or number three, you may represent yourself. That is, you may waive your right or give up your right to have an attorney, and you can represent yourself. Those are the three options. Now, the paragraphs below 1, 2, and 3 states that if you want an attorney to represent you, you have enough money to hire an attorney, your case will be reset. Reset means you'll be given another court date to give you time to hire your attorney. The next paragraph states that if you want an attorney to represent you, but you do not have enough money to hire an attorney, you can request that an attorney be appointed to represent you, but you must first fill out a financial questionnaire. The financial questionnaire is another document on the clipboard. It's a 3-page document that is titled Jefferson County Affidavit of Indigence. Okay, you can turn to that. Jefferson County Affidavit of Indigence. And on that document, what you would have to do, if you just look up for a minute, what you would have to do, you'll fill out the first page. Now, on the bottom of this first page, it asks for your financial information, the monthly income and assets. At the bottom to the left, and at the bottom to the right, it asks for your monthly expenses. Okay? Now, the second page of this document, you have to fill out the top portion that says defendant oath, and then the middle portion that says unsworn declaration by defendant. And that's it. Then you'll stop. Okay? Now, I'm going back to this first page again. And I read the first two paragraphs below 1, 2, and 3. Okay. Third paragraph says that you may not speak to the prosecutor unless you first sign a written waiver of your right to be represented by an attorney. Okay, that's for individuals who would like to represent themselves. If you represent yourself, you'll have an opportunity to talk to the prosecutor, assistant criminal district attorney. How is that possible? It's possible because at that point, you're representing yourself. You are acting as your own lawyer. So therefore, just like the lawyer can talk to them on your behalf, if you're representing yourself, you can talk to them on your behalf. Okay? So that's what that basically means. But before you can talk to them, you must first sign a written waiver. Now, the written waiver is another document, probably the second document on that clipboard. It should be titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Document looks like this. You'd have to read and then you'll sign and date the document. Okay? Now, going back to the first document again. This paragraph right here, right? It says, be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. That's what this says. Now, if you choose to represent yourself, last paragraph states that you may change your mind at any time and request that an attorney be appointed to represent you. Okay? Now, there's a statement in bold letters that says defendant's choice. Mark initials next to only one choice. All right. Now, if you would like to hire your own attorney, then you'll place your initials on the first line to the left and then stop. You'll place your initials there, then you'll sign where it says defendant and the day's date. Okay? Which is January 7th, 2025. So if you want to hire an attorney, this is the only document that you have to sign. Okay? You read this, you sign your initials on the first line, put your signature on the line that says defendant dated, and then you stop. Now, for individuals who would like to apply for a court-appointed attorney, okay, the third line down here says, I request that an attorney be appointed to represent me. You'll place your initials on that line. Okay? Then you will sign your name on the bottom where it says defendant. You will date today's date, January 7th of 2025. And then you will go to the document, the affidavit of Jefferson County Affidavit of Indigence. Fill this document out. First page, second page, you will fill the sign at the top where it says defendant's oath, and then where it says unsworn declaration of defendant or by defendant, you'll sign that, and then you'll stop. Now, for those individuals who will be representing themselves, that is waiving their right to have an attorney, then go back to our first document. You will put your initials on the fifth line, says, I waive my right to attorney and desire to represent myself. You put your initials on this line, and then you'll sign it where it says defendant, and you will date it today's date, January 7th, 2025. And once you do that, you have to go to this other document that says waiver of counsel for purposes of entering a guilty plea or proceeding to trial. Then you will read this, sign it, and date it. Okay, so just a brief recap. You hire an attorney, this is the only document that you have to sign. And then you stop. You have to sign those other documents. If you apply for a court-appointed attorney, you sign this document on the third line, initial on the third line, sign it, and then fill out the Jefferson County affidavit. Okay? If you're representing yourself, you place your initials on the fifth line of this document, sign it, date it, and then fill out the waiver of counsel for purposes of entering guilty plea. Okay, does everyone understand? Okay. Now, as a defendant in a criminal case, you also have a right to have a trial by jury. Where those young people are sitting, we call that area the jury box. 6 citizens from Jefferson County will be selected as jurors in your case. They will listen to all of the evidence, listen to the arguments. They will deliberate, and then they will decide whether or not to find you not guilty or guilty. You also have a right to waive or give up your right to have a trial by jury. By giving up your right to have a trial by jury, you would not be having a trial by jury. Your case will come before the judge in one of 3 ways. One way it can come before the judge is by way of a trial. And somebody might say, well, how can it come by way of a trial if I don't want to have a trial by jury? Well, it will come by way of what we call a bench trial. Bench trial means that it's a trial by judge only, no jury. The judge will be the judge and the jury in the case. Okay? The judge will listen to the evidence, listen to the arguments. The judge will apply the law to the facts of the case and decide to whether to find you not guilty or guilty. The other way that your case can come before the judge is by way of a plea bargain. It can come by way of what we call an agreed plea bargain. Agreed plea bargain. A plea bargain basically is an agreement that you work out with the state to settle your case. And so if you work out an agreement with the state or the district attorney to settle your case, it comes before the judge. The judge can do one of 2 things. The judge could accept or reject your plea bargain agreement. Now, if the judge rejects your plea bargain agreement, let's say you and the state have worked out an agreement for you to do probation. And the judge said, well, I'm not going to follow that agreement. Well, you can tell the judge, well, judge, I take my plea back or I withdraw my plea. You have a right to do that if the judge does not follow the plea bargain agreement that you worked out with the state. Now, if the judge does follow the plea bargain agreement, and if you decide within 30 days that, you know what, I think I've been wrongfully convicted or the court committed an error by convicting me, and I like to appeal my case. If that happens, you have to get permission from the judge to appeal your case. If the judge follows the plea bargain agreement, now if the judge gives you permission, then your case is going to leave this court and it's going to go right upstairs to the 9th Court of Appeals, and there's 4 judges up there. They're going to review the case to see whether or not your appeal should have been granted or whether or not this court committed an error by convicting you. Now, they could do one of 2 things. They can grant or deny your appeal. If they grant your appeal, they can simply find you not guilty, case over. Or they can send the case back down to this court, and this court can give you a whole new trial. Now, if they deny your appeal, you can appeal it to a higher court than the Ninth Court of Appeal. You can appeal it to the highest criminal court in the state of Texas, which is the Texas Court of Criminal Appeals located in Austin, Texas. You would have to file what is called a pro se petition for discretionary review. And what that means is this: pro se means you'll be representing yourself, and you'll be petitioning the highest criminal court in the state of Texas to review your case to see, one, whether or not your appeal should have been granted, or two, whether or not you've been wrongfully convicted, or whether or not we committed an error, or this court committed an error by convicting you. They can do one or two things. They can grant or deny your pro se petition. If they grant your pro se petition, they can simply find you not guilty and case is over. Or they can send the case back to the Ninth Court of Appeals with orders, or they can send it back down to this court with orders. Now, if they deny your pro se petition, then at that point, the case is complete. Okay. Now, as a defendant in a criminal case, you also have a right, besides your right to have a jury trial, or to your right to have a bench trial, or the right to have to enter into what is called an agreed plea bargain agreement. You can enter into what is called an unagreed plea bargain agreement. What that means is this: you and the state have talked, y'all been unable to work out an agreement, but you want the judge to decide what your punishment is going to be. That's called unagreed plea bargain. And then the judge is simply going to assess punishment within the punishment range of your offense. All right. Now, you also have a right to have witnesses come to court. And witnesses sit in that chair where that microphone is, and a witness, they can testify for you or against you. You represent yourself, or you have an attorney. You can ask a question if you represent yourself. If you have an attorney, the attorney can ask a question. We call it either direct examination or cross-examination. You also have a right to waive or give up your right to have witnesses. Waiving means that you've given up your right. You won't be calling any witnesses. It does not mean that the state will not be calling witnesses, because they will be calling witnesses. You also have what is called a Fifth Amendment right against self-incrimination. I know some of us, we look at television and we see a lot of these shows about law and order. And you might see somebody on the witness stand saying, "I take the fifth." Or the police go up to them and want to ask them questions. They say, "Well, I take the fifth." What that means is they are exercising or invoking their Fifth Amendment right to the United States Constitution to remain silent. Okay? The state can't force them to testify. The government, the DA's office, nobody can force them to testify if they exercise or invoke their Fifth Amendment right against self-incrimination. Okay, now you can waive, which means to give up your Fifth Amendment right against self-incrimination. And if you do so, that simply means that you will be testifying. Now, the next right that you have a right to have what we call discovery. For example, let's say this is the state's file, the DA's office file that they have with the evidence in it, right? You have a right to have access to it, to see all of the evidence. You have a right to see witness statements, your statements, police reports, lab reports. You have a right to see photos, video recordings, listen to audio recordings, see documents or whatever, if they have any kind of instruments. You have a right to have access to that. Now, you can waive or give up your right to have discovery, which means that you will not be having access to it. That's a choice that you have to make. Now, everyone that's here for arraignment, you've been charged, you've been arrested, you're out of jail on bond. You're either out on cash bond, which means you paid the full amount of the bond to get out of jail. You're out on a surety bond, which means that you paid a bondsman a percentage of the bonds to get out of jail, or you're out of jail on what we call a PR bond or a personal recognizance bond, which means that you did not have to pay the money to get out of jail. You just were released under your own personal recognizance with a promise to appear here today. Now, I've said that to say this. Every day that you spent in jail, that jail time can be used toward your punishment. So for example, let's say you spent 5 days in jail and then you bonded out. And let's say you talked to the prosecutor and the prosecutor had worked out a plea bargain agreement with you to serve 5 days in jail. What that means is you will not have to serve any more time in jail because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you've already served. Now, if the state is offering 7 days in jail and you serve 5 days in jail, that means you have to serve only 2 days in jail. Okay, we'll subtract 5 from the 7. Now, every day that you spent in jail can also be used as credit towards your fine and court costs. You are credited $100 for every day that you spent in jail. Okay? And so in a scenario, you spend 5 days in jail, that's $500. So if the state is offering you fine and court costs of $500, that means that you don't have to pay anything. Why? Because you've already spent 5 days in jail. That's $500, so it would be taxed and retired. Now, if they're offering fine and court costs of $700, that simply means you will only have to pay 2 because you already have 500 that you served. And so we'll subtract the 5 from the 7 and use $200. Now, let me back up. You notice I said you get credit for every day that you spent in jail. Okay? Let's say you went in jail, you was booked into jail at 11:59 p.m. last night. And you was booked out of jail at 12:01 a.m. this morning, 2 minutes later. That's 2 days. Why? Because it's 2 different days. You don't go by 24 hours. It's the different days. It goes by the different days, okay? So you get credit for the different days that you're in jail. So you booked in at 11:59 p.m. and get out at 12:01. That's 2 days credit. Okay, not 2 minutes credit. It's 2 days credit. Okay. Now, if you cannot pay your fine and court costs, then the court can convert your fine and court costs to community service. And you'll be credited for every 1 hour community service that you perform at a nonprofit organization, you'll be credited $12.50 that will go toward your fine and court costs. So if you work 8 hours community service, that's $100. Okay, so in the scenario where you owe $200, you work 2 8-hour days, that's $200 you pay your fine and court costs. Okay? Now, Jefferson County has a program. When I say Jefferson County, I'm talking about the district attorney's office. They have a program for first-time offenders. If you ever been in trouble before, it's your first time here, they have a program that's called pretrial diversion. With pretrial diversion, they will dismiss your case. And you can get it wiped off your record. We call it expunged from your record. In order to qualify, it has to be first time getting in trouble. 2, it cannot be an offense, unlawfully carrying a weapon or resisting arrest. And 3, you have to have an attorney to assist you with the application process. So if you get in the program, they dismiss the case, you complete the program, you can get it wiped off, erased, or deleted from your record. We call it expunged. Okay? Now, if you are a veteran of any one of the branches of the United States military, District Attorney's Office has another program that's called Veterans Court, for veterans only. With Veterans Court, if you get into that program and complete the program, they will dismiss the case, and you can get what is called a non-disclosure. Non-disclosure means that your record is sealed to the general public. Notice I said general public. Most of the public is general public, they cannot have access to it, but law enforcement and governmental agencies can. All right. Now, this court, County Court at Law Number 2, Jefferson County, Texas, has a program that I started in March of 2017, within the first 100 days of taking office. God basically laid it on my heart, gave me an idea and a plan that we call the Community Safety Initiative. With that program, the program is designed to address the issue of what we call recidivism. Recidivism is when people commit crimes over and over. That's all it means. And so how do we address that? Well, we address it through the Community Safety Initiative. With the Community Safety Initiative, we have partnerships with agencies in our local community. One of the agencies that we have a partnership with is Spindletop. We have some folks here from Spindletop. They're going to come and talk to you more about the Spindletop program in a few minutes. But basically, Spindletop is our local mental health authority. They have the expertise to address mental health issues. Now, in order to participate in the program, you do not have to be incompetent or insane. You could just merely suffer from depression or anxiety or any other host of mental illnesses. And they have the expertise to address your mental health needs. They will conduct what we call a private interview. It'll either be here in our jury room or at their facilities by telephone, whichever is convenient for you. They can do an assessment and they can develop a treatment plan for either outpatient or inpatient treatment, depending on what your mental health needs are. If you have issues, problems with drugs or alcohol, Spindletop also has a program that is called ATAR. It's an acronym, ATAR, that stands for Addiction, Treatment, and Recovery. We have a partnership with our local Drug and Alcohol Council that has a program that is called OSAR, OSAR, that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs. And what they will do, they can conduct a screening, an assessment, and develop a treatment plan for either outpatient or inpatient treatment. We also have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that has the acronym CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It's a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you're trained in any one of those areas, they will help you to get a job in the area that you're trained in. Now, if you have not graduated from high school and you do not have a GED, they also have a GED program which you can get your graduate equivalent diploma. Now, all these programs that I just mentioned to you are free. It doesn't cost you anything but time. And I like to say in this court, we do not just give time, we take our time. And that simply means that we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to County Court at Law Number 2 of Jefferson County, Texas, we do not just have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. And so if you're interested in any one of these programs, we have brochures that we can give to you so that you can get in contact with the individuals that you need to get in contact with to get into the program. So as I mentioned to you earlier, we have some folks from Spindletop who is going to come and tell you a little bit more about the program. Deputy Hinton and Caitlin, they're going to come and tell you a little bit more about the program that Spindletop has for all.
Thank you, John.
Okay, you want.
Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state commission here in the Sheriff's Department. This is my co-worker, Caitlin. Now, Caitlin is a qualified mental health professional. The reason we are both here this morning in this courtroom is because the judge does care about every single person who comes before the bench. The judge has found, what statistics prove, is those who have legal issues commonly have mental health needs, substance use disorders, or sometimes just a lack of community resources to help you with your particular situation. Now, maybe this is your first time to be in court. It could be your fifth time to be in court. There's still hope. In fact, what we're offering you today has the ability to change your life, but we're going to need something from you. We're going to need you to share that need with us. And we have a way to do that very privately. When you first came in, Caitlin gave you a document. And through that document, we will use that as the means to transfer information so that we can best see how to advocate. And Caitlin's going to explain the document just a little bit better.
So in the beginning of the document, is basic information, name, phone, address, which we will need to be able to contact you. And under how would you like to be contacted, it says call, text, or email. Whatever you check is your preferred method of contact, and I will not contact you in any other way unless you check it in the box. Under that, it says I need help with, and we have a whole lot of options. Like Judge said earlier, there's mental health and substance use, and if you have depression, anxiety, PTSD, or you struggle with alcohol or any type of drug use, all you have to do is check it, and I'll call you and we can talk in depth about that. You don't have to put any details on the paper. Nobody but me and my partner will see it. But if you're uncomfortable, you can just check other and just put please call, and we can just talk about anything that you had checked under that. Yeah, everything else is pretty much self-explanatory.
We also have this, this card here that I want to give everybody as well. It's a 1-800 number. If you ever find yourself in an unsafe place, you can use this number to get help immediately. That's going to be our first resource we're actually going to be able to provide for you today. And just shortly, the court's going to go into recess. When it goes into recess, we'll be able to come out there. I'll be handing this out to everyone who wants one, and we'll also be picking up those documents from you. And we'll answer any questions you have at that time as well. Thank you very much. Thank you, John.
Thank you, Deputy Hinton and Caitlin. Okay, ladies and gentlemen, in a few minutes, we're going to go into recess. And what that basically means, we're going to give you an opportunity to fill out the paperwork that you have. Now, it's going to take some time because once you fill out the paperwork, we're going to pick that paperwork up from you. And then we're going to call you one at a time to come before the bench. And then once we go through the paperwork, you're either going to be put in the category of hired attorney, requesting a court-appointed attorney, or representing yourself. Okay? Now, if you need help with that paperwork, just let us know because we have our court personnel who's here to help you to fill out the paperwork. Only thing you have to do is simply raise your hand. I'll be helping as well with the paperwork. So we're going to try to make this as smooth as possible. Now, if you need to use the restroom, there are 2 restrooms right outside in the hall. The men's restroom is in front of County Court at Law Number 3, which is next door. And the women's restroom is on the opposite side of the hall, in front of the 136, 72nd District Court. Okay? Now, please do not leave the courthouse. If you leave the courthouse and your name is called and you're not here to answer, a warrant is going to be issued for your arrest. You're going to be arrested, placed in Jefferson County Jail, and we're going to have to go through this process all over again. Okay? So it shouldn't take us that long. We're gonna try to, do this as, fast as possible. You can just simply right now, just take the time to fill out the application. Those of you who need help, just simply raise your hand. Okay, and then we're going to have, you to come up. Well, someone is gonna come out there and help you, okay? So at this time, going to be a recess. Let's see what we have. Okay, the first case is cause number M 333-022, case of style, state of Texas versus John Eric Archon or Archon. Huh?
Oakland.
Oakland. Mr. Oakland, would you please come forward? Mr. Oakland, your full name is John Eric Oakland.
Yes, sir.
Mr. Oakland, would you please raise your right hand? Mr. Oakland, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
Mr. Oakland, you may put your hand down. How are you doing, Mr. Oakland?
Not real bad.
Okay. Now, Mr. Oakland, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply, that you would want to hire your own attorney?
Yes, sir.
Now, before you signed and initialed this document, did you, oh, this needs to be copied. Oh, never mind, I think you got it. No, that's all right. Did you understand what you read in this document? And is everything in this document true and correct to the best of your knowledge? Okay. Mr. Oakland, I've read your answers. Mr. Oakland, your case is going to be reset to give you an opportunity to hire your own attorney. Our court coordinator is going to give you a reset. Once you get the reset from the court coordinator, you'll be free to go. Now, before she does that, I need to give you a document. The bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. I'm going to go over this document with you. Okay? And it states as follows: following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release for any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that
Yes.
condition? And condition number 3 does not apply. However, condition number 4 applies because the case that you have, which is a DWI second, is classified as a subsequent offense listed under section 49.04 through 4906 of the Texas Penal Code. Now, condition number 4 states as follows: a defendant whose information charges any subsequent offense listed under section 49.04 through 49.06 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator, and said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court on or before 3 days after today. Do you understand that condition?
Yes, sir. Only thing is, I don't have a vehicle. I don't see me
Okay.
one
Well, so it says
for
that
a while.
it's for any vehicle that you own or operate.
Yes, sir.
Okay.
Understand.
Condition number 5, defendant shall obtain, maintain, pay for, and have no violations with the ignition interlock device, mobile breath device. Any violation will be grounds for revocation. Now, this condition basically states that if you don't have a vehicle, you have to get what is called a mobile breath device. Okay? And you cannot have any violations on this device. If you do, then, your bond can be revoked. Do you understand that? Now, condition number 6, defendant must attend NA meetings 3 times a week and provide proof to the court. I have some documents here that the bailiff is going to hand to you. First document that the bailiff is handing you is a document that you have to bring with you every time that you go to NA meetings. And the sponsor will sign verifying that you did attend. And you will bring that document back to court with you every time that you come to court. Okay?
Okay.
Now, the next document is a schedule of different places that you can go to for AANA meetings. Okay, it's a list of places. Anyone, you can go to the nearest one that's closest to you. Okay, so now do you understand? Okay. Now, if you violate any one of these bond conditions, your bond can be revoked. And if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Now, if you have you ready for it? Just stand in front of the court coordinator. She's going to give you a reset. Once you get your reset, you're free to go and you have a blessed day.
Thank you. Thank you.
That door is locked on that side. Deben Abel Roll? Yes. Mr. Roll, your full name is that Deben Abel Roll?
Yes.
How are you doing?
Good.
Okay, Mr. Roll, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. Mr. Roll, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes.
And is this, is this your signature on the line that's titled defendant?
Yes.
And are these your initials on the line that state you like to hire your own attorney?
Yes.
Okay. Now, Mr. Rowe, before you signed this document, signed and initialed this document, did you read the document?
Yeah.
Did you understand what you read?
Yes.
And is everything in this document true and correct to the best of your knowledge? Okay. So, Mr. Rowe, your case is going to be reset by our court coordinator. You're going to get your reset. Once you get your reset, you're free to go and you have a blessed day. Please stand in front of the court coordinator. You have anybody? Andre Deshawn or Dewan Dugas? Andre Dewan Dugas? What is this came up? It never came up like this before.
There should be dismissal on this one, Judge.
Okay, but how did this came up?
What is it?
I turned it on and all this here came up.
Oh.
Oh, that's on January 6th.
Yeah, those should,
I don't know how they got like that. I mean,
go to,
somebody must
today's
have.
day.
I need to log out. Yes. Mr. Dugas, before we get started. Okay. We just need to inform you that you have a right to have a court reporter to dictate everything that's being said. You also have a right to waive or give up the right to have a court reporter. Do you understand? Now, do you waive or give up your right to have a court reporter? Okay. Let's see. I have, now, Mr. Dugas, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Mr. Dugas, you may put your hand down. How are you doing, Mr. Dugas? You blessed? That's good. Can't be better than being blessed. Now, Mr. Dugas, the state is represented in this case by Attorney Haley Simmons. Attorney Simmons, how are you doing?
I'm great, Judge. How are you?
I'm doing fine, thanks for asking. Now, Mr. Dugas, I have before me in this case, cause number 24-CCCR 2606, a document that is titled Motion to Forfeit. You recognize this document? And is this your signature on the line that's titled defendant?
yes, sir.
Now, before you sign this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of knowledge? And the court is going to grant the motion to forfeit the weapon in this case to the Port Arthur Police Department. Okay. Now, Mr. Douglas, I just signed a motion to forfeit the weapon to the Port Arthur Police Department. State, you have another motion?
The state has filed a motion to dismiss for forfeiture.
Okay. Mr. Dugas, I have before me a motion to dismiss your case. That was filed by the state of Texas. I'm signing this motion to dismiss. I just signed a motion to dismiss. You can get a copy from our court coordinator. Once you get a copy from the court coordinator, you'll be free to go and you have a blessed day. Okay, just please stand in front of the court coordinator.
Do you need this one back, Judge?
What's that? Oh, yeah. Okay. And Mr. Dugas, I'm also signing your judge's explanation that states that you're waiving your right to have an attorney and you represent yourself, and also the waiver that you signed, okay? He was supposed to get him the initial that, you just checked it,
Oh.
Mr. Dugas. Give him a pen. Hillary. Okay. You said a berry?
Oh, that's.
Is she here? You have, I could just sign it if she's not here.
I think they were getting ready to transport them back, Judge.
I could just sign it if she's not here. It's just a dismissal. You already sent. Oh, well. You sent it off, you said Barry, send. Okay. If she's up, if she's there, you could take her out. Is she here?
I didn't know you wanted her out.
No,
I thought
if
you
she was
signed it.
here, we'll have options. She's not here, I could just dismiss.
Okay,
Is
she's in
she-
there.
Just have her to come on out.
Okay, I gotta go down. He's watching.
Okay, this is cause number 24CCCR 2430, case of style of state of Texas versus Cindria Berry, Ms. Berry. Is that your full name? How are you doing, Ms. Berry? That's good. Now, Ms. Berry, I have before me a motion to dismiss your case that was filed by the state. Is that correct, state?
Yes, Your Honor.
And your case in this court is being dismissed. Okay? You can file the bailiff and they'll send this copy to jail as well. All right, you have a blessed day.
You too, thank you.
You're welcome. Rashad Anderson. Oh. Don't lean on the table. Okay. You don't have to put your hands on the table at all. Just stand up, yeah. Now, Mr. Anderson, your full name is Rashad Anderson?
It is.
Okay. Now, Mr. Anderson, let me see.
This is a plea, Your Honor.
Yeah, I see that. I have the paperwork right here. Mr. Anderson, would you please raise your right hand? Mr. Anderson, do you swear affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
You may put your hand down. How are you doing, Mr. Anderson?
Doing good.
That's good. Now, Mr. Anderson, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir, I do.
And is this your signature on the line that's titled defendant?
Yes, it is.
And are your initials on the line that states you would like to waive your right to an attorney and represent yourself?
Yes, sir.
I have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes, sir, I do.
And is this your signature on the line that's titled defendant?
Oh, yes, sir.
Now, Mr. Anderson, before you signed and initialed these documents, did you read the documents?
Yes, sir, I did.
And did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay. Now, Mr. Anderson, before we go any further, you have a right to have a court reporter to type down everything that's being said in this proceeding. You also have a right to waive or give up your right to have a court reporter.
Mhm.
Now, do you waive or give up your right to have a court reporter?
It doesn't matter, Your Honor.
Hmm?
I said it doesn't matter, Your Honor.
Oh, you have to. You
Oh, no, it's fine, no.
So you do not want a court reporter, is that correct?
I just need to know where to sign and to be on my way.
Okay. Now, Mr. Anderson, I also have before me, hold on a minute, on my computer, a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Rashard Anderson, on or about September 30th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of criminal trespass. Mr. Anderson, do you understand what you have been charged with?
No, yes, sir, yes, sir, yes, sir.
And to this charge, how do you plead? Guilty, not guilty, or no contest?
Guilty, but
Now, are you pleading guilty freely and voluntarily?
involuntarily.
And are you pleading guilty because you are guilty?
Yes.
Okay. Now, Mr. Anderson, I also have before me a document on this tablet that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, I do.
Okay. On page 2 of this same document, there are 2 sets of initials. The first set of initials is on a line next to a box that's checked guilty. Did you place your initials on this document?
Yes, I did.
The second set of initials is below a paragraph that is titled Discovery Admonishment and is on a line next to a statement that reads as follows. I do not request discovery of evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials on this document down here?
Yes, I did.
Okay. On page 3 of this same document, there's a signature above the line that's titled defendant. Is this your signature?
Mhm.
And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
I sure do.
And is this your signature on the line that's titled defendant?
Mhm.
At the top of this document, there are 2 boxes that's checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Mhm.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Understand.
Okay. Now, Mr. Anderson, before you signed and initialed all of these documents,
Mhm.
did you read the documents?
I read them.
And did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay. Mr. Anderson, are you a citizen of the United States?
Absolutely.
State offer states one.
Okay. Now, Mr. Anderson, the state is offering State's Exhibit number 1 to be used against you in your case. Now, State's Exhibit number 1 is the first document on this tablet that you acknowledge.
Mhm.
Saying this is the same document that have your initials in these 2 locations
Mhm.
and your signature on page 3. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
Okay, no objections. State's exhibit number 1 will be admitted. Now, Mr. Anderson, is there any evidence that you are currently mentally incompetent to stand charged? To stand trial, okay?
No, no.
Okay, Mr. Anderson, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering 7 days in the Jefferson County Jail, credit for 7 days, and to tax and retire all court costs.
Okay, Mr. Anderson, the state is offering that you serve 7 days in the Jefferson County Jail, but you will not have to serve any more time in the Jefferson County Jail because you've already served 7 days. Therefore, you'll be given credit for the time that you've already served. Mr. Anderson, the court costs in this case will be taxed and retired. That simply means that the time that you have spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Mr. Anderson, do you understand the state's offer?
Yes, sir, I do.
And do you think that the state's offer in your case is fair and just? And do you accept the state's offer? Okay, Mr. Anderson, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Anderson, you're going to stand next to the bailiff, follow her directions. Once you're finished following her directions, you're free to go, and you have a blessed day. Carmen Nina Arredondo. Miss Arredondo, your full name is Carmen Nina Arredondo? Ms. Arredondo, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Okay, you may put your hand down. How are you doing, Ms. Arredondo? That's good. Ms. Arredondo, the state is represented in this case by Attorney Andrew Hubel. Attorney Hubel, how are you doing?
Doing well, Judge, thank you.
And Ms. Arredondo, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Carmen Nina Arredondo, on or about September 8th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of reckless driving. Ms. Arredondo, do you understand what you've been charged with? And to this charge, how do you plead? Guilty, not guilty, or no contest?
Okay.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Now, Ms. Arredondo, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Now, Ms. Arredondo, I had to make a change on here. There's one box that's checked. The box that's checked states that this is a Class B misdemeanor, and the range of punishment for a Class B reckless driving is maximum, a sentence that does not exceed 30 days in the Jefferson County Jail and a fine that does not exceed $200. Do you understand that?
Yes, sir.
That's the range of punishment. Or you could be given both such fine and confinement. On page 2 of this same document, there are 2 sets of initials. The first set of initials is on a line next to a box is checked. No contingent, which means no contest. Did you place your initials on this document? The second set of initials is below a paragraph that is titled Discovery Admonishment and is next to a statement that reads as follows. I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials in the second location? On page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature? The next document is titled Trial Court Certification of Defendant's Right of Appeal. You recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document, Ms. Arredondo, that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled defendant? And are these your initials on the line that state you like to waive your right to an attorney and represent yourself? I also have another document that's titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. You recognize this document? And is this your signature on the line that's titled defendant? Now, Ms. Arredondo, before you signed an initial, all of the documents that I just showed you, did you read the document? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay. Ms. State, you like to offer State's Exhibit Number 1?
Yes, Your Honor.
Ms. Arredondo, the state is offering State's Exhibit Number 1 to be used as evidence against you. State's Exhibit Number 1 is the document that is titled Misdemeanor Plea Admonishment. Is the first document that you acknowledge. This is the same document that have your initials in the 2 locations on page 2 and your signature on page 3. Is it all right for the state to use these documents as evidence in your case? Okay, no objections. State's Exhibit Number 1 will be admitted. Now, forgot to ask, are you a citizen of the United States? Okay. And the other thing is you have a right to waive, you have a right to have a record made. That is that you have a right to have a court reporter to type down everything that's being said. You also have a right to waive or give up your right to have a court reporter. Do you waive or give up your right to have a court reporter? Okay. Now, Ms. Arredondo, is there any evidence that you are currently mentally incompetent to stand trial? Is there any evidence that you have, that you are mentally ill, are you unable to go forward and unable to understand what's going on? Okay. Now, State, well, let me do this here. Ms. Arredondo, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
The agreement in this case is to 6 months deferred probation with a $200 fine and 24 hours community service.
What's the court cost? Okay. Ms. Arredondo, the state is offering that you serve 6 months deferred adjudicated probation. During the 6-month probationary period, you'll be required to pay a fine of $500 plus court costs of $330.
No, the fine was 200, Your Honor.
What I said? Okay, yeah, okay, you'll be required to pay a fine of $200. Court costs of $330. You'll also be required to pay a probation fee of $6 a month, your analysis fee of $15 a month, reimbursement fee of $15. The total monthly installments, that is the total amount that you'll be required to pay each month, is $199 a month. Will you be able to pay the $199 each month?
Yes, sir.
You'll also be required to perform 24 hours of community service and adhere to the other standard terms and conditions of your probation. Do you understand? Now, do you understand the state's offer?
Yes, sir.
You think the state's offer in your case is fair and just? And do you accept the state's offer? Okay, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Ms. Arredondo, if you successfully complete this probationary period, this case will be dismissed. It would not result in a conviction on your record, and you may qualify for a non-disclosure. You can talk to an attorney about the non-disclosure. Please stand next to the bailiff, follow her directions. Once you finish following her directions, you'll be free to go, and you have a blessed day. Nina Guillory? Is that Nina? No, not Nina.
All right.
Naraya Guillory? Okay. Okay. Court is in session in 2 cases. Cause number 24 CCC Aura 2630. And cause number the other one is not on here.
2631, Judge.
Oh. And cause number 24 CC CR 2631. Both cases are styled in the state of Texas versus Nariah Guillory. Ms. Guillory, is that your full name? Ms. Guillory, would you please raise your right hand? Ms. Guillory, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God? Ms. Guillory, you may put your hand down. How are you doing, Ms. Guillory? That's good. Ms. Guillory, you have a right to have a court reporter to dictate or type down everything that's being said. You also have a right to waive or give up the right to have a court reporter. Do you waive or give up the right to have a court reporter? Okay, now, Ms. Guillory, I also have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Nariah Guillory, on or about September 4th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of theft. Ms. Guillory, do you understand what you have been charged with? And to this charge, Ms. Guillory, how do you plead? Guilty, not guilty, or no contest? Are you pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges? Ms. Guillory, I also have before me on my document, well, on paper, a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled defendant? Are these your initials on the line that state you like to waive your right to an attorney and represent yourself? I also have another document that's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You recognize this document? And is this your signature on the line that's titled defendant? Ms. Guillory, before you signed and initialed these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct?
Yes.
To the best of your knowledge? Ms. Guillory, I also have before me on my computer a document on this tablet that is titled Misdemeanor Plea Admonishments. You recognize this document? And is this your signature on the line that's titled defendant? Oh, next page. On page 2 of this document, there are two sets of initials. The first set of initials is on the line next to a box that's checked nolo contendere, which means no contest. Did you place your initials on this document? Second set of initials is below a paragraph that is titled Discovery Admonishment and is next to a statement that states as follows. I do not request discovery. I waive my right to discovery. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. You place your initials on this document. On page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature? On the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. You understand that statement? Now, Ms. Guillory, before you signed and initialed these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Ms. Guillory, are you a citizen of the United States?
State offers states one.
Ms. Guillory, the state is offering states exhibit number 1, which is the misdemeanor plea admonishment, to be used as evidence against you in the case. This is the document that the first document on this tablet that you acknowledge. This is the same document that has your signatures in these 2 locations. And this is the same document that has your signature on page 3. The state would like to use this document as evidence in your case. Is it all right for the state to use this document as evidence in your case? Okay, no objection, state's exhibit number 1 will be admitted. Ms. Guillory, are you a citizen of the United States? Ms. Guillory, is there any evidence that you are currently mentally incompetent to stand trial? There's none? Okay, Ms. Guillory, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering 1 year deferred probation, $500 fine, 40 hours community service plus court costs, and this is to run concurrent with the companion case.
Ms. Guillory, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $500 plus court costs of $277. You'll be required to pay a probation fee, $6 a month, your analysis fee of $15 a month, reimbursement fee of $15. Your total monthly installments, that is, the total amount that you will be required to pay each month is $154 a month. Will you be able to pay the $154 each month? You will also be required to perform 40 hours of community service. This case will run concurrent with the companion case, cause number 24CCCR 2631. And you will also be required to adhere to the other standard terms and condition of probation. Ms. Guillory, do you understand the state's offer? Do you think that the state's offer in your case is fair and just? And do you accept the state's offer? Ms. Guillory, I'll follow the plea bargain agreement that you have entered into with the state. Now, Ms. Guillory, we move on to your next case. Your next case is cause number 24CCCR 2631. And in this case, Ms. Guillory, I have before me a motion or information rather that was filed by the Jefferson County District Attorney's Office. And in this information, it alleges that you, Nariah Guillory, it's the same date, September 4th. On about September 4th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offensive theft. Ms. Guillory, do you understand what you have been charged with? And to this charge, Ms. Guillory, how do you plead guilty, not guilty, or no contest? Now, are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? I also have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document? On page 2 of the same document, there's 2 sets of initials. One set of initials is below a paragraph that is titled, waiver. It's next to a line that is titled nola contingere, which means no contest. You place your initials in this location. Second set of initials is below a paragraph that is titled discovery admonishment, and it is your initials are next to a statement that reads, I do not request discovery of evidence. I've waived my right to request discovery of the evidence in this case and choose to enter a plea of no contest, guilty. Did you place your initials on this document? On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature? On the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. First box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Now, Ms. Guillory, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
State offers states 1.
Now, Ms. Guillory, the state is offering state's exhibit number 1 to be used as evidence in this case. State's exhibit number 1 is the first document that you acknowledge on the tablet that have your initials on page 2 in the 2 locations and your signature on page 3. Is it all right for the state to use this document as evidence in your case? Okay, no objection. State's exhibit number 1 will be admitted, and the court, Ms. Guillory, is going to find that you are competent to stand trial. The court will accept your plea of no contest. The court will also find that your plea and waivers were freely and voluntarily made. The court will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt, and you're found guilty. Now, state, do we have a plea bargain agreement?
We do, Your Honor.
Let me back up. The court has found that there's sufficient evidence to find you guilty beyond a reasonable doubt. At this time, the court is not finding you guilty. Okay, you may go forward.
The state's offer in this case in exchange for defendant's plea is 1 year deferred probation, fine is to be waived, 40 hours community service court cost, and this is to also run concurrent with the companion case.
40 hours community service.
Yes, Your Honor.
No fine. So we won't have that. We won't have that. We just have this. Okay, Ms. Guillory, the state is offering that you serve 1 year deferred adjudicated probation during the 1 year probationary period. You will not be required to pay a fine. However, you will be required to pay a probation fee of $277. Because this case is running concurrent with the previous case, you will not be required to pay a probation fee in this case, and you will not be required to pay the your analysis fee of $15 each month in this case. You will be required to pay a reimbursement fee of $15. Your total monthly installments, that is the total amount that you'll be required to pay in this case, is $27 a month. Will you be able to pay the $27 each month? You'll also be required to perform 40 hours of community service. This case will run concurrent with the previous case, cause number 24 CCCR 2630, and you'll be required to adhere to the other standard terms and conditions of this probation. Now, Ms. Guillory, do you understand the state's offer? Do you think the state's offer in your case is fair and just? Do you accept the state's offer? Okay, now, Ms. Guillory, I'll follow the plea bargain agreement that you have entered into with the state. Now, Ms. Guillory, if you successfully complete these probationary periods, these cases will be dismissed, will not result in a conviction and record, and you may qualify for a non-disclosure. You can talk to an attorney about the non-disclosure. Now, you're going to stand you're gonna have to, yeah, you're gonna stand in front of the bailiff. Now, before you do that, the second case is gonna show that you're paying a probation fee and a urinalysis fee. But when you get to the probation office, because you're on probation for two of these cases, you won't have to pay it in the second case. Do you understand that? All right, stand next to the bailiff. Once you stand next to the bailiff, you're free to go and you have a blessed day. Now, Ms. Guillory, I need to tell you something. Once you finish with that, once you finish print, she's taking your print. I think everybody else is just. Okay, Ms. Giller, you can come back up. Now, Ms. Giller, I see that you're here, you're not here by yourself. Who do you have here with you? Your dad? Okay, thanks for coming out here with your daughter, sir. Now, Ms. Guillory, I know a lot of times, young people tend to think or tend to say that they have a BFF, best friend for life. They have somebody that they consider, they call it a ride or die. That person to be with them through thick and thin. And it's usually somebody that's one of your peers, one of your girlfriends or boyfriend or whatever. But on days like today, that person that you call your BFF, I don't see him here today. Now, the person I see you call your ride or die, that you call your ride or die, I don't see them here today. However, I see your father here today. And the reason why your father is here, because that's your BFF, that's your ride or die, because that's the person that put a roof over your head, clothes on your back, food on the table, and then from time to time, he probably had to put a little spanking on your butt. And he did all of those things because he loved you, right? That's why he's here today. I know today, I tell people this all the time. Everybody's not your friend, everybody's not your partner. But when that man say he got you, he got you. Okay. And a lot of times, this is not this is not a place that he wants to be. He could be doing other things today besides being here with you. But he's here today. And, to you, you might think, oh, my life is over. It's the end of the world. Well, you might thinking, oh, I'm going through this storm. But I need you to understand that when you're walking through a storm, hold your head high and don't be afraid of the dark. At the end of the storm, there's a golden sky and a sweet silver song of the Lord. Walk on through the wind, walk on through the rain, though your dreams be tossed and blown. Walk on with hope in your heart, and you'll never walk alone. Now, this may look to you as it may seem to you that this is a stumbling block, but you can use it as a stepping stone. Okay, that is, a stepping stone is something that you use to reach higher heights. Okay, this is not the end. Okay, you can put this all behind you by cooperating with the things that you're supposed to do on your probation. And you still can accomplish anything that you want to accomplish in life. You're one of the fortunate ones. And you're fortunate because you have a father that's here with you. A lot of times there are people here in your age, they don't have a mother or father here. But you have a father here. And you probably need to hug that man, tell him you love him because he loves you, okay? And when you leave here and you get this behind you, make him proud of you. Okay? Okay, thanks for coming down here, sir. And continue to hang in there with her. We just hang in there with her. You know, I tell people, hang on, don't hang up. All right? So y'all have a blessed day. Okay, you're welcome. Joshua Holloway? His case is gonna be, Holloway's gonna be reset. Okay. Mr. Holloway, how you doing? Okay, Mr. Holloway, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, Mr. Holloway, you may put your hand down. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant? Are these your initials on the line that state you'd like to waive your right to attorney and represent yourself?
Yes, sir.
I also have a document that's titled Waiver of Counsel for purposes of entering guilty plea or proceeding the trial. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled
Yes,
Defendant?
sir.
Now, Mr. Holloway, before you sign and initial these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Now, Mr. Holloway, I thought the prosecutor stated that they need time to talk to complaining witness in this case. Hold on a minute. Yeah. And your case is going to be reset to give them time to do that. Okay? Now, before your case, once your case is reset, you're free to go and you have a blessed day. Now, before you do that, the bailiff is going to hand you a document that's titled Standard Bond Conditions. And do you see that title, Standard Bond Conditions in County Court Law Number 2? Do you see it? Okay, I'm going to go over this document with you. And it states as follows: following the return of a criminal information in County Court at Law Number 2, all bail bonds are executed for release of any defendant named herein or orders subject to the additional condition. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Now, condition number 3 states that the defendant shall not communicate either directly or indirectly with the alleged victim of the offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
Condition number 4 does not apply. However, condition number 5 does apply. Condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that? Now, Mr. Holloway, if you violate any one of these conditions, your bond can be revoked. If your bond is revoked, warrant issued for your arrest, you'll be arrested and placed in the Jefferson County Jail. He has a copy that's all original. Okay. Please stand in front of the court coordinator. And once you get your receipt, you're free to go. Jesus Castro. Okay. Mr. Castro, your full name is Jesus. Jesus Castro Jr. Okay, Mr. Castro, would you please raise your right hand? Swear affirm and tell the truth, the whole truth, and nothing but the truth, so help you God. Mr. Castro, you may put your hand down. How are you doing, Mr. Castro? That's good. Now, Mr. Castro, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without an Attorney. Recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant? Are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that's titled Jefferson County Affidavit of Injury. Do you recognize this document?
Yes, sir.
And is this your signature on the line that is titled Defender Signature. Who's Jay Castro? Did you show this to her? He said that's not his signature. Well, who signed it? Where it says Defender Signature? Did you fill out that form?
Yes. This,
Okay, let's erase it then.
I saw it and I was like, what, I wonder who did that.
Oh, that must have been already, that must have already had that already on there. Let me see. They must have given him a document that already had a thing filled
Yeah,
out.
because you
That's
can
all.
tell by how he wrote December.
Okay, let me see. Let me just write it out. And somebody.
He writes with capital letters and he prints it out.
No problem. Glad, that's why we ask. And that's why we show it to you. Okay, he can go ahead on and sign that. The day is the 7th of January. Okay, now, Mr. Castro, before you sign and initial these documents, all these documents that I just showed you, did you read the documents?
Yes, sir.
You understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Castro, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. Attorney that will be appointed to represent you as Attorney Langston Adams. Mr. Adams will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you're free to go and you have a blessed day. Please stand in front of the court coordinator.
Thank you.
Francisco Persicato Barracon. Barracon. What is this? Is that Francisco Antonio Preciado Barragan? Okay, how are you doing? I'm doing fine, thanks for asking. Would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. Now, I have before me two documents. The first document is titled Judgment Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line is titled Defendant? And are these your initials on the line that state you like to apply for court-appointed attorney? Also have a document that is titled Jefferson County Affidavit of Industries. You recognize this document?
Yes, sir.
And on page 2 of the same document, there's a signature above the line that's titled Defender Signature. Is this your signature? Now, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct? The best you know. Okay, Mr. Barragan, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney Don Boudreaux. Attorney Boudreaux will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once you get the information, you're free to go. You have a blessed day. Please have a seat in that second chair.
Thank you.
You walk to Johnny Johnson. Mr. Johnson, your full name is Johnny Raymond Johnson.
Yes, sir.
Mr. Johnson, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. How are you doing, Mr. Johnson?
I'm doing all right.
I'm doing fine. Thanks for asking, Mr. Johnson. I have before me two documents. First document is titled Judge's Explanation of Rights to defendants without attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you like to apply for
Yes,
court
sir.
appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes, sir.
And is this your signature on page 2?
Yes, sir.
Now, before you sign and initial these documents, did you read the document?
Yes, sir.
Did you understand what you read?
Sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Johnson, I read your answers. Based on the answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. An attorney that will be appointed to represent you. In your case is Attorney Tom Burbank. Attorney Burbank will be given information to contact you. You will also be given information to contact him. Our court coordinator is going to give you that information. Once you get that information, you're free to go and you have a blessed day. Please have a seat on the wall. First chair. Kendall Chopin.
Mr. Burbank, the trial is going.
Yeah, she can give him a reset. Okay, Kendall Chopin. Okay, how you doing, Mr. Chopin?
Good.
Chopin, would you release, raise your right hand? You swear to affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you may put your hand down. Now, your attorney is currently in trial in another court, so you can't be here at the same time. Now, are you in school?
Supposedly, right now.
Yeah, I'm saying, but you were in school, right? That's why we set it on this date. Hold on a minute. Have a seat right there, and we gonna call you right back. Why don't you come on up? Now, are you out of school just for this day or for the week?
To the 21st.
Till the 21st of this month? Okay, what we might want to do is reset it to next week. So that, because we want to try to get you in before you go back to school. Okay, so just reset it next week.
Could you make note, keep all this at the school? I'm tired of them insinuating this to me.
We're not sending anything to the school. I don't know what you're talking about.
I don't know who they're getting the information from.
Oh, I don't know. Yeah,
It's a 12 witness trial next door, so.
Yeah.
Be better later on in the week if possible.
yeah, just gonna reset it. Put him in the middle, they said it's a 12 witness trial, so let's put him in the middle of the week.
It's a.
Yeah, because he has to go back to school about the 21st, I think he said, right? Yeah, is the 15th fine? That's, is that a what? Wednesday, okay. She gonna get you reset. Once you get your reset, you'll be free to go and you have a blessed day. Mr. Chopin, would you come back on up? Mr. Chopin, did I swear you in?
Yes, sir.
I did. Okay, now, Mr. Chopin, how are you doing?
Good.
That's good. Now, Mr. Chopin, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that state you would like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature on the line that is titled Defendant's Signature. Is this your signature? Now, Mr. Chopin, before you sign and initial these documents that I just showed you, did you read the document? Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Chopin, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. An attorney that will be appointed to represent you in your cases is Attorney Christy Cawthon. Attorney Cawthon will be given information to contact you, and you will be given information to contact her. Once our court coordinator give you that information, you're free to go, and you have a blessed day. Please have a seat in the chair on the wall. All right. Matthew Artis. Mr. Artis, your full name is Matthew Artis?
It is.
Mr. Artis, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Artis, you may put your hand down. How are you doing, Mr. Artist?
I'm fine.
I'm doing fine, thanks for asking. Mr. Artist, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant?
It is.
And are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? And on page 2 of this same document, there's a set of initials on the line next to a box that's titled Defendant Signature. Is this your signature?
There.
Now, Mr. Artist, before you sign and initial these documents, did you read the document?
I did.
And did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
There.
to the best of your knowledge? Mr. Artist, I read your answers. Based on your answers, you meet the eligibility requirement for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you is Attorney Mark Fagger. Attorney Fagger will be given information to contact you, and you will be given information to contact him. Our court coordinator is going to give you that information, but before she gives you that information, the bailiff is going to give you a document that is titled Standard Bond Conditions in County Court at Law number 2. Mr. Artist, do you see that title, Standard Bond Conditions in County Court at Law number 2?
Yes, sir.
Okay, I'm going to go over this document with you, and it states as follows. Following the return of a criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
I do.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs, alcohol, in the defendant's body. Do you understand that condition?
Yes, sir.
Now, condition number 3 does not apply. However, condition number 4 does apply because your case, which is a DWI second, is a subsequent offense listed under section 49.04 through 49.06 of the Texas Penal Code. And condition number 4 states as follows. A defendant who information charges any subsequent offense listed under section 49.04 through 4906 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes it practical to operation of such vehicle if ethyl alcohol is detected in the breath of the operator, and said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court on or before 3 days after today. Do you understand that condition?
I do.
And condition number 5, defendant shall obtain, maintain, pay for, and have no violations with the ignition interlock device, mobile breath device. Any violation will be grounds for revocation. Do you understand that?
Yes, sir.
And condition number 6 states that the defendants must attend AANA meetings 3 times a week and provide proof to the court. Do you understand that condition?
Yes, sir.
Now, the bailiff is going to hand you 2 forms. The first document is a verification form that will verify every time that you go to AANA meetings, a sponsor is going to sign, and you need to bring that document with you when you go to the AANA meetings and every time that you come to court. Okay? And that's the second set of documents that she's handed out is locations in Jefferson County or in our Southeast Texas region where you can attend AANA meetings. Okay. Now, do you understand these bond conditions?
I do.
Now, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Okay, please have a seat. Yes.
If I'm not driving a motor vehicle, how do I go forward?
Or if you don't, you have to have that device on any vehicle that you own or operate. Now, if you don't operate a motor vehicle or own one, you have to get a mobile breath device. Okay? And if you need to find locations, they probably could go to the same place where you get the interlock, I would imagine. But she can give you a copy of locations. Timmy Horace. Mr. Horace, your full name is Timmy Horace?
Yes, sir.
Horace, would you please raise your right hand? Do you swear, affirm, and tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Horace, you may put your hand down. How are you doing, Mr. Horace? That's good. Now, Mr. Horace, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Mr. Horace, do you recognize this document?
Yes,
And is this your signature on the line that's titled defendant?
yes, sir.
And are these your initials on the line that state you like to apply for court appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Injuries. You recognize this document?
Yes, sir.
And on page 2 of the same document, there's a signature above the line that is titled defendant signature. Is this your signature? Mr. Horace, before you sign and initial these documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Horace, I read your answers. Based on the answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Jack Lawrence. Attorney Lawrence will be given permission to contact you, and you will be given permission to contact him. Our court coordinator will give you that information. Once you get that information, you're free to go on your blessed day. Please have a seat in that second chair on the wall. Teddy Knighton. Mr. Knighton. Your full name is Teddy Knighton? Yes. Mr. Knighton, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth? So help you God? Mr. Knighton, you may put your hand down. How are you doing, Mr. Knighton? You doing all right? Well, Mr. Knighton, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Recognize this document? And is this your signature on the line that's titled defendant? Are these your initials on the line that state you like to apply for court appointed attorney? I also have another document that's titled Jefferson County Affidavit of Injuries. You recognize this document? And on page 2 of the same document, there's a signature above the line that is titled defendant signature. Is this your signature? Mr. Knight, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Knight, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney, and the attorney that will be appointed to represent you is Attorney Todd LeBlanc. Attorney LeBlanc will be given permission to contact you, and you will be given permission to contact him. Once you get that information from our court coordinator, you'll be free to go, and you have a blessed day. Please have a seat in that third chair on the wall. Terrence Grant. Mr. Grant. Your full name is Terrence Grant?
Yes, sir.
Mr. Grant, would you please raise your right hand? Swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Grant, you may put your hand down. How are you doing, Mr. Grant?
Thank you, fine.
Okay, you can't complain. It could be worse, huh? I understand that. Now, Mr. Grant, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Or are these your initials on the line that state you like to apply for court appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Injuries. You recognize this document? On page 2 of the same document, there's a signature above the line that is titled defendant signature. Is this your signature?
Yes, sir.
Now, Mr. Grant, before you signed and initialed these documents, did you read the documents?
Yes, sir.
And did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Okay, now, Mr. Grant, I read your answers. Based on your answers, you do not meet the eligibility requirements for the appointment of a court-appointed attorney. So at this point, you have two options. You can either, ask that your case be reset to give you an opportunity to hire an attorney, or you can waive your right to have an attorney, that is, give up your right to have an attorney and represent yourself.
I represent myself.
Okay. Well, we need to give him a waiver. And yeah, she's gonna give you a waiver, and then you're gonna have to put your initials on, strike through the first one and put your initials on the second one, okay? You know what? Oh, no. Yeah. You can have a seat at the on that table. He has a pen?
Yeah, right.
Okay. He can sit down and fill that out. You can sit down at the table and fill it out. You don't have to stand up.
Oh, wait, yeah, that.
One of them? Yes.
The Terrence grant. Do we have any phone? His name is Chopin. Kendall Chopin.
Oh, no, okay, okay, no.
Okay, I don't think we have any bond for Patricia. We'll be in recess. So, oh, okay. Mr. Grant, you can come back up. Mr. Grant, I swear you back in. You swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Okay, Mr. Grant, I have before me a document that's titled Judge's Explanation of Rights of Defendants Without Attorney. And you recognize this document? And is this your signature online as titled defendant?
Yes, sir.
And are these your initials online saying you want to waive your right to attorney and represent yourself?
Yes, sir.
I also have a document that's titled waiver of counsel for purposes of enter guilty plea or proceeding to trial. You recognize this document?
Yes, sir.
And is this your signature on the line as titled defendant?
Yes, sir.
Now, before you sign and initial these documents, did you read the documents?
I can read the second one.
Okay, well, let me do this. I'm gonna give you opportunity to read it because you need to read before you sign. Okay? Grant. Showing your document that's titled waiver of counsel for purposes of enter guilty plea or proceeding to trial, you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant? Now, before you, well, have you read this document? And you understand what you read? And is everything in this document true and correct to the best of your knowledge? Okay? Now, Mr. Grant, just take a seat. And you can sit right there, and then one of the prosecutors will come out, will talk to you about your case. Okay. Okay, this is cause number 24 CCCR 2530. Case is styled the state of Texas versus the Terrence Grant. Mr. Grant, would you please come forward? Mr. Grant, would you please raise your right hand and you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Now, Mr. Grant, your full name is Terrence Rayjard Grant. How are you doing, Mr. Grant?
Good.
Okay, well, that's a good thing. Could be somewhere else. Like 6 feet under, you know, you're on top of the dirt is not on top of you. So that's a good thing. Now, Mr. Grant, I have before me 2 documents that we went over earlier. The first document, waiver of counsel, first to enter guilty of fear proceeding to trial. You acknowledge that this is your signature on this document. Also, Jefferson County judge's explanation of rights to defendants without attorney, you acknowledge your signature and initials are also on this document. Is that correct? You also acknowledge that you, before you sign or after you sign these documents, you read the documents in its entirety and you understood what you read. And is everything in these documents true and correct? Okay, I also have another document before me in this case that is titled Motion to Forfeit. Forfeit the weapon to the Beaumont Police Department. Is this your signature on the line that's titled defendant?
Yes, sir.
Now, before you sign this document, did you read the document?
Mhm.
You understand what you read?
Yep.
And is everything in this document true and correct to the best of your knowledge?
Yep.
Okay, Mr. Grant, I'm going to sign this motion, granting the motion to forfeit the weapon, in this case, to the Beaumont Police Department. State, do you have an additional motion?
The state has filed a motion to dismiss for forfeiture, Your Honor.
Okay, Mr. Grant. The state is going to dismiss your case for forfeiture of the weapon, and you still had something? Let me give you this tablet. You can get it up. Here you go. Okay, I'm gonna sign the dismissal. Once you get a copy of the dismissal, you'll be free to go. And you have a blessed day. Now, if you need a certified copy, you probably can get that later on today from the county clerk's office, which is directly below us.
Okay.
Okay? But we can give you just a copy of what I'm signing here now. It has to go through the system to get the file stamp on it and all that other stuff through the clerk's office. All right? So your case is being dismissed. You can just have a seat in that first chair on the wall, wait for your name to be called. And this will conclude the calling of the court's docket. The court's arraignment docket on today's date, January 7th, 2025, in County Court at Law Number 2, Jefferson County, Texas. Judge Terrence L. Holmes presiding. Everyone, please have a blessed day.
Thank you.
You're welcome. And prosecutors, you are excused.